Please be seated. The sitting is open. The court meets today and will meet in the coming days to hear the parties' oral arguments as well as the examination of their experts in the case concerning dispute over the status and use of the waters of the Silala, Chile versus Bolivia. This afternoon, the court will hear the first round of oral argument by Chile on its own claims. Owing to the ongoing concern related to the COVID-19 pandemic, the court has decided to hold these oral proceedings in a hybrid format under Article 59, Paragraph 2 of its rules. The court has taken great care to ensure the smooth conduct of this hybrid hearing. The parties participated in technical tests prior to the opening of the hearing. These tests were comprehensive and included, for example, tests of the interpretation system and the process for displaying exhibits. However, while these tests reduce the risk of technical difficulties, they cannot eliminate them. In the event that we experience any such difficulty, such as a loss of audio input from a remote participant, I may have to interrupt the proceeding briefly to allow the technical team to solve the problem. In a hybrid hearing such as this one, all judges are able to view the speaker and any demonstrative exhibits, regardless of whether they are in the Great Hall or joining via video link. I would like to note that the following judges are present with me in the Great Hall of Justice: Vice President Gevorgyan and Judges Tomka, Benuna, Yusuf, Shway, Sebatinde, Iwasawa, Nolta, and Charlesworth, while Judges Abraham, Bandari, Robinson, and Salam, and Judges ad hoc Dode and Zima are participating by video link. For reasons duly made known to me, Judge Cansado Trindade is unable to sit with us in these oral proceedings, either in person or by video link. For this hybrid hearing, the registrar informed both parties that each of them could have up to 8 representatives present in the Great Hall of Justice at any one time, and that in addition, 2 members per delegation could sit in the gallery. The parties were moreover informed that the court could make available, should a party so desire, an additional room in the Peace Palace from which other members of the delegation could follow the proceeding via video link, and that participation via video link would also be available to further members of each delegation who would not be present in the Peace Palace. Since the court included on the bench no judge of the nationality of either party, each party proceeded to exercise the right conferred upon it by Article 31, Paragraph 3 of the statute to choose a judge ad hoc to sit in the case. Chile chose Mr. Bruno Zima and Bolivia, Mr. Yves Daudet. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, Paragraph 6 of the statute, the same provision applies to judges ad hoc, who must make a new solemn declaration in each case in which they participate, as stated in Article 8, Paragraph 3 of the Rules of Court. In accordance with custom, I shall first say a few words about the career and qualification of Professor Daudet and Judge Zima before inviting each of them to make his solemn declaration. Professor Yves Daudet, who is of French nationality, is a doctor of law and professor in public law and political science. He is currently president of the Curatorium of the Hague Academy of International Law and emeritus professor at the University of Paris I, Panthéon-Sorbonne, where he served as the first vice president. Professor Daudet is an arbitrator in the Court of Conciliation and Arbitration within the Organization for Security and Cooperation in Europe. He has held a number of academic and research posts in France, Mauritius, Morocco, and Côte d'Ivoire. He was a member of the French delegation to the United Nations Conference on the International Code of Conduct on the Transfer of Technology. He has been chosen as a judge ad hoc on numerous occasions and is currently sitting in the case concerning alleged violation of sovereign rights in maritime spaces in the Caribbean Sea, Nicaragua v. Colombia, in the 2 cases concerning application of the Convention on the elimination of all forms of racial discrimination, Armenia versus Azerbaijan and Azerbaijan versus Armenia, and in the case concerning allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, Ukraine versus Russian Federation. Professor Daudet is a member of the editorial board of the Annuaire Français du Droit International and is a member of the French Society of International Law and the French branch of the International Law Association. He has published numerous books and articles in different areas of international law. Judge Bruno Zimmer, of German nationality, served as a member of this court from 2003 to 2012 and was chosen as judge ad hoc in the joined cases concerning maritime delimitation in the Caribbean Sea and the Pacific Ocean, Costa Rica versus Nicaragua, and land boundary in the northern part of Isla Portillos, Costa Rica versus Nicaragua. Judge Zimmer studied law at the University of Innsbruck, where he obtained a doctoral degree in 1966. In 1973, he became professor of international law and European community law at the University of Munich, where he went on to serve as the dean of the Faculty of Law between 1995 and 1997. Judge Zimmer also has a long-standing academic career at the University of Michigan Law School, where he began teaching in 1986, was appointed professor of law in 1987, and where a chair has been created in his name in 2009. He has twice been the director of studies at the Hague Academy of International Law, and in 2009, he delivered its prestigious general course in public international law. His publications in international law are numerous and well known. Judge Zimmer was a member of the United Nations International Law Commission from 1996 to 2003. He has appeared as advocate in various cases before the court and has sat as arbitrator in numerous important arbitration cases. Since 1 December 2012, he has been an arbitrator at the Iran-U.S. Claims Tribunal. Judge Zimmer is the recipient of numerous awards, including honorary doctorate degrees. In accordance with the rules of procedure fixed by Article 7, Paragraph 3 of the Rules of Court, I shall first invite Professor Daudet to make the solemn declaration prescribed by the statute, and I request that all those present rise. Professor Daudet, you have the floor.
I solemnly declare that I will perform my duties and exercise my powers as judge honourably, faithfully, impartially, and conscientiously.
Judge Daudet, we lost the audio, so if you could try again to make your declaration, I would be grateful.
Excusez-moi, Madame la Présidente.
I do apologise, Madam President. Let me start again. I solemnly declare that I will perform my duties and exercise my powers as judge honourably, faithfully, impartially, and conscientiously.
Professor Daudet, I now invite Judge Zimmer to make the solemn declaration prescribed by the statute. Judge Zimmer, you have the floor.
I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously.
I thank Judge Zimmer, and please be seated. I take note of the solemn declarations made by Judge Ad hoc Daudet and Judge Ad hoc Zimmer and declare them duly installed as judges ad hoc in the case concerning dispute over the status and use of the waters of the Silala, Chile versus Bolivia. I shall now recall the procedural steps in the present case. On 6 June 2016, the Republic of Chile filed in the registry of the court an application instituting proceedings against the plurinational state of Bolivia with regard to a dispute concerning the status and use of the waters of the Silala. To found the jurisdiction of the court, Chile invokes Article 31 of the American Treaty on Pacific Settlement signed on 31 April 1948 and officially designated, according to Article 60 thereof, as the Pact of Bogotá, to which both states are parties. By an order of 1 July 2016, the court fixed 3 July 2017 and 3 July 2018 as the respective time limits for the filing of a memorial by Chile and a counter-memorial by Bolivia. Chile filed its memorial within the time limit thus fixed. By an order of 23 May 2018, the court, at the request of the respondent, extended until 3 September 2018 the time limit for the filing of its counter-memorial. Bolivia filed its counter-memorial within the time limit thus extended. In Chapter 6 of its counter-memorial, Bolivia, making reference to Article 60 of the Rules of Court, submitted 3 counterclaims. By an order dated 15 November 2018, in the absence of any objection by Chile to the admissibility of Bolivia's counterclaims, the court did not consider that it was required to rule definitively at that stage on the question whether the counterclaims fulfilled the conditions set out in Article 80, Paragraph 1 of the Rules of Court. It directed the submission of a reply by Chile and a rejoinder by Bolivia, limited to the respondents' counterclaims, and fixed 15 February 2019 and 15 May 2019 as the respective time limits for the filing of those written pleadings. The reply and the rejoinder were filed within the time limits thus fixed. By an order of 18 June 2019, the court authorized the submission by Chile of an additional pleading related solely to the counterclaims of Bolivia and fixed 18 September 2019 as the time limit for the filing of that pleading. Chile filed its additional pleading within the prescribed time limit. By letters dated 15 October 2021, the registrar informed the parties that the court had decided that hearings would be held from 1 to 14 April 2022. The parties were also informed that, pursuant to the decision of the court, each party was requested to call during the hearings the experts whose reports were annexed to its written pleadings. By the same letters, the registrar informed the parties of the court's decision that they should each provide, by 14 January 2022, a written statement summarizing their experts' reports. The contents of the written statements were to be limited to a summary of the experts' findings already provided in their reports, setting out the points on which the parties considered themselves to be in agreement, but focusing primarily on the issues on which the experts remained divided. Chile and Bolivia filed the written statements summarizing their expert reports within the time limit as fixed by the court. Chile's written statement was prepared by Mr. Howard Wheater and Mr. Dennis Peach, and Bolivia's written statement was prepared by Mr. Roar Jensen, Mr. Torsten Jakobsen, and Mr. Michael Gabora. Pursuant to Article 53, Paragraph 2 of its rules, the court decided, after ascertaining the views of the parties, that copies of the written pleadings and the documents annexed thereto, as well as the written statements of the experts, would be made accessible to the public on the opening of the oral proceedings. I would now like to welcome the delegations of the parties. I note the presence before the court of the agent of the Republic of Chile and the agent of the plurinational state of Bolivia, accompanied by members of their respective states' delegations. I would also like to welcome the eminent representatives of the Chilean and Bolivian governments present at today's hearing, namely, Her Excellency Ms. Antonia Orejola, Minister of Foreign Affairs of the Republic of Chile, who is joining us by video link, and His Excellency Mr. Rogelio Minister of Foreign Affairs of the plurinational state of Bolivia, who is present in the Great Hall of Justice. In accordance with the arrangements on the organization of the procedure decided by the court, the hearings will comprise a first and second round of oral argument. The first round will begin with Chile's presentation today of its arguments on its own claims from 3 p.m. to 6 p.m. Bolivia will present its first round of argument both on the claims of Chile and on its own counterclaims on Monday, 4 April from 3 p.m. to 6 p.m. and on Tuesday, 5 April from 3 p.m. to 5 p.m. On Wednesday, 6 April, Chile will present its observations on the 2 counterclaims of Bolivia on the counterclaims of Bolivia from 4 p.m. to 6 p.m. 2 sittings will then be held dedicated to the questioning of the experts called by the parties. The experts appointed by Chile will be heard on Thursday, 7 April between 3 p.m. and 6 p.m. And those called by Bolivia will be heard on Friday, 8 April between 3 p.m. and 6 p.m. The second round of oral argument will open on the afternoon of Monday, 11 April, with Chile addressing the court from 3 p.m. to 5 p.m. on its own claims. On Wednesday, 13 April, Bolivia will present its second round of arguments on the claims of Chile and its own counterclaims from 3 p.m. to 6 p.m. On Thursday, 14 April, Chile will present its reply on the counterclaims of Bolivia from 3 p.m. to 4 p.m. In this first sitting, Chile may, if so required, avail itself of a short extension of time beyond 6 p.m. in view of the time taken up by my introductory remarks. I now give the floor to the agent of Chile, Her Excellency Ms. Jimena Fuentes Torrijos. You have the floor, Excellency.
Madam President, distinguished members of the Court, it is an honor to appear before the International Court of Justice on behalf of the Republic of Chile. I will be making some short introductory remarks in my role as Chile's agent in this case, before looking at the case in more detail, and in particular to explain why there is and can be no answer from Bolivia to the central claims that Chile makes before you. I would like to take this opportunity to acknowledge the presence of Chile's Minister of Foreign Affairs, Ms. Antonia Urrejola, who attends Chile's oral arguments online in Santiago, Chile. I would also take this opportunity to respectfully greet the Bolivian delegation. Chile is committed to develop a fruitful relation of cooperation with its neighbor, the plurinational state of Bolivia, on the basis of due respect for mutual rights and obligations under international law. There are numerous areas in which Chile and Bolivia need to cooperate for the benefit of the two countries and their inhabitants living on both sides of the boundary. Chile and Bolivia share an international boundary of more than 800 kilometers. They also share many natural resources, including rivers and aquifers in the Atacama Desert, one of the driest places on Earth. This dispute is concerned with one such shared resource, the Silala River system. Chile asks the court to confirm the status of the Silala as an international watercourse and the rules that govern the relationship between Chile and Bolivia as co-riparians. In 1999, Bolivia abruptly and for the first time denied that the Silala River was an international watercourse, claiming that these waters belong entirely to Bolivia and that they have been diverted into Chilean territory. On 23 March 2016, former President Evo Morales announced Bolivia's intention to bring Chile before the court to stop what he called an illegal use of the waters of the Silala by Chile. Later, Bolivia announced that it would take 2 years to initiate legal proceedings against Chile. Chile decided to bring this dispute before the International Court of Justice without delay, in the belief that a more speedy clarification of the rights and duties of the two states regarding the status and use of the Silala River system would provide the parties with an opportunity to develop strategies of cooperation instead of being trapped in flawed legal and scientific premises. In order to understand the dispute, which has been greatly narrowed in the course of the exchange of written pleadings, please allow me to put it in its geographical and historical context. The Silala River is located in the Atacama Desert, as I have just noted, one of the driest places on Earth. Reaching the Silala River, even today, requires some serious effort. The Silala River is located in the highlands of the Atacama Desert, at more than 4,300 meters above sea level, where the climate is harsh, vegetation is scarce, and fresh water even scarcer. Despite its small size, its high-quality waters have been of great importance to the development of the Antofagasta region in Chile. For municipal uses in cities and towns, such as Antofagasta and Calama, and for industrial uses, including the railway from Antofagasta to La Paz, operative since the last decade of the 19th century. The Silala River is a shared watercourse. It flows from about 4 kilometers in Bolivia and a further 6 kilometers in Chile, before joining the San Pedro River. It arises from springs in Bolivia that nourish two associated wetlands, Cajones and Orientales, also referred to as the northern and southern wetlands. Subsequently, we will refer to the Cajones and Orientales wetlands jointly as the Silala wetlands. In Bolivia, the discharge from the Orientales wetlands enters a ravine, where it is joined by the discharge of the Cajones wetlands. After this junction, the river continues to flow within the ravine, with walls on both sides of over 30 meters high. It crosses the international boundary into Chile with an average flow of 170 liters per second. Downstream of the border, groundwater sources contribute an additional surface flow of about 124 liters per second. Against this backdrop of the importance of the Silala River in an extremely arid region, I will first introduce in a little more detail the background to the current dispute before explaining how, in the course of these proceedings, the issues in dispute have been reduced to such an extent that Chile considered it possible and sought to achieve a negotiated settlement following receipt of Bolivia's rejoinder. However, since that has turned out to be impossible, I will conclude by explaining that the dispute over the waters of the Silala River at least provides the court with an opportunity to affirm the applicability of the basic principle of reasonable and equitable utilization in these times of increasing fresh water scarcity. Madam President, members of the court, prior to 1999, the status of the Silala River as an international watercourse had never been disputed by Bolivia or Chile. Bolivia's southern about-face in 1999 was not based on any scientific foundation. It was seemingly motivated by claims of the people from the Bolivian department of Potosí, where the headwater springs of the Silala River are located, that Chile should pay compensation for its use of the waters. For almost 100 years, the parties had agreed that the Silala River naturally flowed from Bolivia to Chile. There is ample evidence of Bolivia's recognition of the international character of the Silala River, including documents, maps, and explicit declarations by Bolivia's own authorities. Most notably, this is evidenced first by the map appended to the 1904 Treaty of Peace and Amity between Bolivia and Chile that depicts the Silala River crossing from Bolivia into Chile, signed by the Bolivian ambassador in Chile, Mr. Alberto Gutiérrez, and the Chilean Minister of Foreign Affairs, Mr. Emilio Bello Codecido. Second, by Bolivia's participation in joint demarcation and revision activities in the Silala area in 1906, 1924, and as recently as 1991 and 1992. And third, even more recently, in 1996, by a public statement by Bolivian ambassador Teodosio Imaña Castro, then chair of the Bolivian Boundary Commission and president of the Mixed Boundary Commission, in which he confirmed, and I quote, "The inclination of the terrain has been established by experts to be around 30%. Its riverbed is narrow, and its crystalline waters follow the course that, due to the force of gravity, goes downhill into Chilean territory," close quotation. Indeed, geological and geomorphological studies show conclusively that the river has flowed from what is now Bolivia to what is now Chile for at least 8,400 years. As to its uses, the Silala River and its surroundings have supported human habitation, animal herding, and possibly wildlife hunting for at least the last 1,500 years, as confirmed by the archaeological evidence found on the terraces along the Silala River ravine in Chile. In modern times, the waters of the Silala River have been used pursuant to licenses granted by both Chile and Bolivia. As will be further explained later by Dr. Klein-Kranenberg, in 1906, a concession was granted by the government of Chile to the Antofagasta, Chile and Bolivia Railway Company, FCAB, for the use of the waters of the Silala to provide potable water to the Chilean port city of Antofagasta, some 300 kilometers away. 2 years later, in 1908, a concession was granted by the government of Bolivia to the same company for the use of the waters of the Silala River to supply water to the steam engines operating on the Antofagasta-La Paz Railway. After FCAB obtained these permits, waterworks and earth channels were excavated along the Silala River in Bolivian and Chilean territory. Bolivia terminated the 1908 concession in 1997. Since then, FCAB only operates the intake on Chilean territory. The late 1990s also marks the time when Bolivia started to question the status of the Silala as an international river and began to affirm, both in public and in diplomatic notes, that, I quote, "the spring waters of the Silala, granted by the 1908 concession, do not constitute a river, let alone a binational river or shared waters, and that the waters that are formed in Bolivian territory would be consumed in that same territory if it were not for the intake, transport, and control works made by the concessionaire company," close quotation. On these grounds, Bolivia claimed 100% ownership of the waters of the Silala. Between 2000 and 2010, Chile agreed to engage in negotiations and attempts to settle the dispute with Bolivia. This ended abruptly when Bolivia asked Chile to pay for the past use of the waters of the Silala in Chilean territory, the so-called historic debt theory. The origin of this can be found in promises made by President Hugo Banzer in 1999 to the people of Potosí, when he announced that his government, and I quote, will recover the waters of the Silala spring being usurped by Chile, and that Potosí will see important revenues, not yet quantified, in the not too long term, close quotation. One important aspect of the Bolivian claim that Chile has diverted the waters of the Silala is that Bolivia never attempted to put before Chile serious scientific studies on the basis of which the two parties could have initiated a fruitful dialogue. In point of fact, the first time that scientific studies commissioned by Bolivia about the functioning of the Silala River have been shared with Chile has been during these proceedings before the International Court of Justice. These studies, presented with Bolivia's counter-memorial, confirm what Bolivia had denied for years in the period from 1999 to September 2018, that the Silala River naturally flows along the topographic gradient from Bolivia into Chile. In light of this, Bolivia has, in the proceedings before you, returned to where it was before 1999 and no longer questions the status of the Silala as an international river. Madam President, members of the Court, as you may have noted from the written proceedings, in many aspects, the parties have reached a common understanding upon the nature and use of the Silala River, thanks to notable changes in Bolivia's position. In and from 1999, Bolivia not only took the position that the Silala River is not an international watercourse, it also maintained that Bolivia has 100% sovereignty over its waters, that Chile has no right to its reasonable and equitable use, that Chile should therefore pay retroactively for past uses of the waters of the Silala, and that Bolivia has no obligations to Chile with respect to it. Notably, following Chile's decision to submit the case before this court, Bolivia has now abandoned the idea that the Silala is not an international watercourse and has accepted that the Silala flows naturally from Bolivia into Chile. This is Chile's claim A. It has also acknowledged that as an international watercourse, the Silala is governed by the principle of equitable and reasonable utilization, and that the duties to consult and to prevent significant harm are also applicable. These are Chile's claims B and D. Bolivia has even recognized that Chile's past and current use of the Silala as an international watercourse is reasonable and equitable. This is Chile's claim C. This means that the historic debt claim has seemingly been abandoned by Bolivia, at least in its submissions before the court, insofar as Bolivia acknowledges the international status of the Silala River, the right of the two riparians to benefit from this international watercourse in accordance with international law, and that its claim for compensation for the so-called artificial flow refers to a future delivery of the said artificially flowing waters and depends on Chile's consent. Taking into account that Bolivia now accepts Chile's position on so many of the issues that were in dispute, one has to ask, why are we still here before the court? The short answer is that Bolivia still insists that it owns a portion of the waters of the Silala River, and that, although it is reluctant to state this in plain terms, Chile should agree to pay for the use of that portion. Bolivia has labeled this portion of the flow as artificial flow, allegedly an addition to the surface water flow and allegedly generated as the result of the small channels that the FCAB company excavated on Bolivian territory in around 1928. Remarkably, according to Bolivia, the alleged artificial flow of the Silala River is not governed by the principle of equitable and reasonable utilization, but by the rule of territorial sovereignty. Thus, the key remaining legal issue in the current case is whether international law recognizes the distinction introduced by Bolivia between natural and artificial surface water flows, on which its partial defense to Chile's claims and its counterclaims 2 and 3 are based. Bolivia's thesis is that the groundwater that naturally flows down the gradient into Chile, but which, due to the channelization works on Bolivian territory, constructed by Bolivia's licensee in 1928, may now flow down a channel as surface water instead of groundwater, is correctly characterized as artificial water. It would be manifestly contrary to international law for Bolivia to assert exclusive sovereignty over the groundwater flowing to Chile. Yet, somehow, according to Bolivia, once the groundwater flows on the surface, due to the drainage effect of the channelization works on Bolivia's territory, this is said to become artificial water, over which Bolivia can claim exclusive sovereignty. That position, with all due respect, is obviously untenable. Indeed, Chile wonders how Bolivia's thesis, which was never mentioned during the development of this dispute between November 1999 and September 2018, can seriously be pursued before this court. And there is no disagreement on any relevant factual issue before the court, as all parties agree that, whether as groundwater or as surface waters, the waters of the Silala, after due allowance for minimal evaporation, flow down the gradient to Chile. Against this background, in June 2019, Chile proposed to Bolivia the terms of a settlement, but it received no reply from Bolivia. In that proposed settlement, the parties would have recognized that both states are entitled to the equitable and reasonable use of the Silala River, and that Bolivia can dismantle the channels as it sees fit. I would like to devote some comments regarding this last issue. As the court is aware, Bolivia's case is that the channels dug on its territory generate what it calls an artificial flow of surface water. Its case on artificial flow lacks any basis in international law, but it also lacks any coherent factual basis. It was not Chile that authorized the construction of the channels on Bolivian territory, nor does Chile ask for them to be retained, nor is it relevant whether the channelization results, as Bolivia claims, in an increase in the surface water flow. All the waters of the Silala River, less minimal evaporation losses, flow from Bolivia into Chile due to the natural topography of the terrain, either as surface or as groundwater flow. Chile has no objection to Bolivia dismantling the channels. Chile has made clear in its written pleadings, and is happy to reiterate, that if the removal of the channels, which of course will be done with due care by Bolivia, were to lead to a reduction of the surface water flows in Chile or to any drop in water quality, this would not per se infringe Bolivia's obligations regarding the Silala River as an international watercourse. In its rejoinder, Bolivia has manifested its concern that Chile will somehow object to the dismantling of the channels on the basis of a protection of Chile's present uses. Chile has already clarified this point in paragraph 119 of its additional pleading, stating that, and I quote, Bolivia's principal concern seems to be that Chile's principled position that it is entitled to its current use of the waters of the Silala River means that Bolivia's rights to dismantle the artificial infrastructure could be constrained if its actions resulted in a reduction in the current flow regime, such that it prevents Chile from enjoying its existing uses. Close quotation. However, Chile has clearly stated in paragraph 120 of its additional pleading that, and I quote, a reduction, if any, of the cross-boundary surface flow resulting from the dismantling of the channels in Bolivia would not be considered a violation of customary international law unless the obligations that Bolivia has accepted were somehow engaged. Close quotation. Further, during the current proceedings, Bolivia has manifested its interest in restoring the Silala wetlands in its territory, even though it had never communicated such interest to Chile before. Indeed, the first indication of this concern was received by Chile with Bolivia's counter-memorial. Again, Chile supports a restoration, but we emphasize that any past or future degradation caused in Bolivia by the acts and omissions of Bolivia is not something that Chile could conceivably be responsible for. And we are puzzled by how degradation for which Bolivia would be responsible has come to feature in Bolivia's case. Even though the dispute has been significantly reduced, the issue that the court is called upon to decide can be seen as important in the context of climate change and water scarcity. The ill-conceived concept of artificial flow raises the following legal question before the court. Thus, an upstream state have sovereignty and exclusive rights over the augmented surface flow of a shared water resource resulting from waterworks constructed in that state's territory? This question needs to be answered by reference to the current factual situation where the additional surface flow would be at the expense of groundwater that would anyway be flowing to the downstream state. The concepts of artificial flow and exclusive sovereignty have no place in the law of international watercourses. In times of increasing scarcity of fresh water, countries are called upon to cooperate in the efficient management of their shared water resources. This might imply the implementation of technical improvements and sometimes the construction of waterworks, which may well lead to increases in surface water flows at the expense of groundwater flows. On analysis, Bolivia's contention is, with respect, absurd. Madam President, members of the court, the Silala case, however small the Silala River may be, and despite the fact that the issues in dispute have narrowed, provides the court with a valuable opportunity to confirm certain basic principles of the international law of shared freshwater resources. Principally, that all riparian states have a right to the reasonable and equitable use of an international watercourse, and that the law of international watercourses does not permit an upstream state to charge its downstream neighbor for controlling the flow of such a watercourse. Dr. Klein-Kranenberg will now look in a little more detail at the history of the utilization of the Silala River, and she will show the court how the activities on Bolivian territory, which form the basis of Bolivia's defense, were licensed by Bolivia under the 1908 Bolivian concession granted to a private English company, and that Chile has had no involvement in those activities. Professor Stephen McCaffrey will then develop the point that international law does not recognize a distinction between natural and artificial flows, and that the principles of equitable and reasonable utilization, prevention of significant harm and cooperation apply to all waters of the Silala River's system. Regrettably, due to personal reasons, Professor McCaffrey is unable to present his oral arguments. I am grateful to Professor Alan Boyle, who has agreed to deliver Professor McCaffrey's speech on his behalf. And then Professor Laurence Boisson de Chassournet will demonstrate that Chile's historical uses of the Silala waters are in accordance with the principle of reasonable and equitable use. She will also explain that Chile recognizes Bolivia's right to use the waters of the Silala in accordance with the principle of equitable and reasonable utilization in case a need for water from the Silala arises in Bolivian territory. Finally, Mr. Sam Woodworth will identify how all the expert issues that are relevant to the court's determinations in this case have been agreed. Thank you for your kind attention. Madam President, I ask you to give the floor to Dr. Johanna Klein-Kranenberg.
Thank you, Your Excellency. I now invite Ms. Johanna Klein-Kranenberg to take the floor. You have the floor, Madam.
Madam President, members of the Court, it is an honor to appear before you on behalf of the Republic of Chile. Chile's agent has impressed upon you the importance of the Silala River for the development of the Antofagasta region in Chile, one of the most arid places on Earth. She has also noted Bolivia's recognition of the Silala River as an international watercourse, with the exception of a portion of the waters which Bolivia calls its artificial flow. This artificial flow is said to be caused by the channels on Bolivia's territory. My task today is to show you that these channels and any other waterworks in Bolivia were carried out by an English company, pursuant to a license granted by Bolivia in 1908, from which it follows inevitably that the channels and the alleged artificial flow are not in any way attributable to Chile. I will also briefly refer to the uses of the Silala River in Chile for human consumption and industrial development, and show that Bolivia, by contrast, has thus far not demonstrated any use or need for the water in its territory. If it were to do so, then of course, Bolivia would be entitled to a reasonable and equitable utilization of the Silala River. So my main point today is that the channels on Bolivian territory were carried out by an English company, pursuant to a Bolivian license granted in 1908. The company in question is the Antofagasta, Chile and Bolivia Railway Company Limited, also known as FCAB. Established in London in 1888, the company's main line of business was the construction and the operation of the railway from the Chilean port city of Antofagasta to La Paz in Bolivia, as you can see from the photos on the screen. Its second line of business consisted in the supply of potable water to Antofagasta. This city has no local water supplies and is entirely dependent on fresh water supply from elsewhere. Water was also necessary for the operation of the steam engines of the railway, so the two lines of business were closely related. The FCAB archives in London provide a full account of 1. FCAB's identification of the Silala River as a valuable water resource in 1905. 2. How the company obtained the water rights, first in Chile in 1906 and 2 years later in Bolivia. 3. The construction of the first intake and the start of operation in 1910. And 4. The later construction of the channels in Bolivia in 1928. To look at the documents in a little more detail, the general manager of FCAB wrote to the board of directors in London in December 1905 that, and I quote, "News was obtained of a large supply from a river, the Siloli." This is one of the various names of the Silala River. Also flowing into the San Pedro Salar, where its waters disappear. Samples were taken from a point in this river called El Cajon, and the quality, as per analysis enclosed, was found to be excellent. There's a large volume of water flowing down the river Siloli, which is probably the principal source of the San Pedro River, as from the Salar. End of quote. This, it should be noted, is incontrovertible evidence of the abundant flow of the Silala River on Chilean territory before any waterworks were constructed. 6 months later, in June 1906, the general manager informed the board in London that the application for the concession of the Silala waters had been approved by the Chilean authorities. He also noted down in handwriting, "I shall now endeavor to obtain the concession for the springs which are in Bolivian territory." The Bolivian concession was necessary for FCAB's railway business. the Chilean concession of the Silala River had been granted solely for the purpose of increasing the potable water supply for Antofagasta. But FCAB also needed good quality water to run its steam engines, and Bolivian legislation gave preference to the railway companies to use public waters. In its application to the Bolivian authorities, which is an integral part of the public deed of the concession, FCAB explained that by building intake and channeling works, the previously mentioned springs could be used, and the company plans to execute such works to use the waters for its railroad services. The company also made the point that there is no population in the vicinity of the river in Bolivia that depends on it. On October 28, 1908, FCAB's application was approved as requested, including its proposal to construct the necessary waterworks on Bolivian territory. As you can see on the screen, the Bolivian concession was granted by the prefect of Potosí without any conditions or qualifications, confirming in the broadest possible terms that, by virtue of this public instrument, the company is even more vested with the quality of true and only holder of the concession and grantee of the use of the Sololi waters, without there being any person who can claim a better right. This 1908 Bolivian concession, which remained in force until 1997, provides the legal basis for all waterworks executed by the company in Bolivia, including the excavation and lining of the channels that now feature so centrally in Bolivia's case before you. Once both licenses were obtained, FCAB constructed certain waterworks in Bolivia. These comprised an intake in Bolivia at about 600 meters upstream from the international boundary, just below the confluence of the two tributaries of the Silala River, flowing down from the Orientales, or southern, and Cajones, or northern, wetlands. And a pipeline to transport the water from the intake in Bolivia to FCAB's existing water reservoirs at San Pedro Station in Chile. From San Pedro Station, the water was transported to Antofagasta over a total distance of approximately 300 kilometers. A second intake on Chilean territory was constructed much later in the 1940s, and this is still used by FCAB. As to the initial intake in Bolivia, in a letter to the Bolivian Treasury dated August 3, 1910, the company informed the Treasury that it must send into national territory a pipe for the waters of the Silala River, which have been granted to said company by the prefecture of the Department of Potosí. And it requested authorization to send the pipe through Chilean territory. This was, of course, pursuant to Bolivia's 1908 concession. On November 23, 1910, the Silala water reached the reservoir at San Pedro Station. As noted down by the general manager, the pipeline is good and the water is now in service, thus marking the beginning of the modern usage of the Silala River. The channels in Bolivian territory on which Bolivia relies for its legal defenses were dug more than 17 years later, in 1928, for sanitary reasons. In a letter of January 27, 1928, to the Board of Directors in London, the General Manager of FCAB explained that certain eggs of flies have been discovered under microscopic examination in the water of Antofagasta. The cause was finally traced to the headworks in the Sololi Valley, where there is considerable vegetable growth through which the water has to flow before reaching the intake. The schemes for overcoming this difficulty have been prepared by the waterworks engineer, the first that of cleaning up the course of the water through the valley by cutting an earth channel from the upper springs to the existing intake works, and also a branch trench from the Cajon Springs near the intake. This puts to rest any theories embraced by Bolivia in the past that the channels were built to divert the waters from Bolivia into Chile. Here, I would like to take a moment to stress the importance of the waters of the Silala River for the development of the Antofagasta region. The Silala River supplied the city of Antofagasta with potable water until alternative solutions were developed in the late 1950s. Also in the late 1950s, FCAB started to replace its steam engines with diesels, a process that was completed during the 1980s. Since then, and as of today, FCAB delivers the waters of the Silala River to distributors and mining companies where it is still used as potable water due to its high quality and for mining processes. FCAB recently confirmed that 37% of the waters of the Silala extracted by the company is still used for human consumption, either by local communities or by workers at the mining companies. Since the 1950s, the Chilean national copper company, Codelco, has also used the waters of the Silala River following construction of an intake approximately 4 kilometers downstream from the intake of FCAB. Codelco also has recently confirmed that 51% of its portion of the Silala River is used as potable water for the workers in the Chuquicamata copper mine near the city of Calama. In short, the water of the Silala River has been used in Chile for more than 110 years, mainly for human consumption and for the operation of the railway, and later also for industrial uses. Thanks to the high natural quality of the waters of the Silala, human consumption still accounts for a significant percentage of its use. Now, coming back to the history of the licenses. In 1997, Bolivia terminated the 1908 Bolivian concession. The reason was that the water was no longer used for railway purposes. This meant that FCAB had to abandon its intake in Bolivia and could no longer maintain the channels that it had constructed under license in Bolivian territory, although it has continued to extract waters from its intake on Chilean territory. I should note that by this time, FCAB was owned by private interest in Chile, although it was and still is an English company. There are two important points to be made about Bolivia's own actions following its termination of the 1908 concession. First, Bolivia has not itself used the waters since 1997, although it has tried to sell the waters to users in Chile. In the year 2012, Bolivia developed a fish farm and announced the construction of a bottling plant, but these were unsuccessful and the projects were eventually abandoned. As far as Chile is aware, there is no current use of the waters in Bolivia other than for a military post, which was established in 2006. Second, in the 25 years following the termination of the 1908 Bolivian concession in 1997, Bolivia has not taken any material steps towards the restoration of the Silala wetlands, despite its recent declarations of intent before this court. Once the 1908 concession was terminated, if not before, there was nothing to stop Bolivia from dismantling the channels in its territory and restoring the wetlands to their natural state. However, it has chosen not to do so. We don't know why. This brings me back to the main point of my presentation today, concerning the inevitable absence of any responsibility on Chile's part for any impacts of channels constructed on Bolivia's territory pursuant to the license issued by Bolivia. Madam President, members of the Court, Bolivia has made the channels in its own territory the centerpiece of this case. Before Chile brought this case before the court, Bolivia claimed that the channels had diverted the water from Bolivia to Chile, and that without the channels, the water would stay put in the wetlands. Bolivia has rightly abandoned this claim. Bolivia's current claim is that the channels have increased the surface water of the Silala River, albeit to the detriment of the groundwater flow. This increase it has called artificial flow, although there's nothing artificial about it. Bolivia claims that the artificial water is somehow exempted from the application of accepted principles of international water law. Shortly, Professor McCaffrey, through the voice of Professor Alan Boyle, will explain to you why this is not a tenable position under international law. Mr. Wordsworth will later explain that, as a matter of fact, the concept of artificial flow does not assist Bolivia in the present case because even Bolivia's own experts, DHI, recognize that all the waters of the Silala River system eventually flow from Bolivia into Chile, be it as surface or groundwater flow. The point for now is that even if the artificial flow existed and had relevant legal meaning, any consequences would have to be attributed to Bolivia, not to Chile, since Chile had nothing to do with the construction of the channels. This provides a complete answer to Bolivia's defenses in this case concerning the flows of the Silala River, and likewise a complete answer to its counterclaims. Bolivia itself has recognized this as recently as in 1999. In an exchange of notes between Bolivia and Chile, following the termination of the 1908 Bolivian concession and Bolivia's related public statements that the Silala was not a river, the Foreign Ministry of Bolivia reminded Chile that this was an issue between Bolivia and a private company. And I quote, "It is worth emphasizing that said concession was granted by the Prefecture of Potosí to a private company and not to the Chilean state." Hence, Bolivia's foreign ministry says, quite correctly, all actions undertaken to date, as well as those that the cited company carried out, were in the private sphere and with full acknowledgement of the Bolivian jurisdiction. Bolivia added that the actions undertaken by the Bolivian state concerning the undue use of the aforementioned waters fall wholly as appropriate on the company that received the concession in 1908. It would be incomprehensible for the Chilean state to want to attribute said responsibility to itself. End of quote. Madam President, members of the court, I have explained to you that all the waterworks in Bolivia, including the channels in the wetlands that were dug in the late 1920s for sanitary reasons, were carried out by FCAB under the 1908 Bolivian concession with Bolivia's knowledge and consent. Chile has no responsibility for these waterworks and, in the words of Bolivia's foreign minister, it would be incomprehensible for the Chilean state to want to attribute said responsibility to itself. I thank you for your kind attention, Madam President. This may be a good moment for a coffee break, after which Professor Alan Boyle will deliver the oral arguments of Professor Stephen McCaffrey. on his behalf. Thank you very much.
I thank Ms. Klein-Kronenberg. Before I give the floor to the next speaker, the court will observe a coffee break of 15 minutes. The sitting is adjourned.